Hello, good afternoon. How are you today? Very happy to have you again on our show. And today is about accent litigation, and we're going to be guiding you on how to understand the court system in Nigeria. How does the court system work? We've seen cases of people that show up and then just say, I want to sue this person and I want my case to go to this place and all of that. And let me share just one example. So Ade, for instance, now this is a fictitious name, not relating to any Ade that you know out there. So Ade had walked up to his lawyer and mentioned that he wanted to sue Bosse for maybe on a case of defilement relating to somebody. And then it then turned out that he said, well, so I know one judge somewhere. I want that judge to be the one to handle my case. And then the question is, well, it's good you know somebody, but what are the standards when it comes to going to court? Can you take a matter before somebody just because you know that person? And then, can you even take a matter to any court at large just because you want your matter to go before that particular court that you have in mind? So let's start with our first question. Generally speaking, there is something that is called you cannot be a judge in your own cause. The meaning of that is that the moment there is an element that can affect justice, where the judge, the person to decide the case, would become like a party in the same case. Let's say by reason of some affinity, of some relationship that is likely to now cast some element of doubt in neutrality of the judge, meaning if at the end of the day, because of this relationship, is it possible to say this judge, this person that is sitting to decide this case, may not be able to decide without any element of favor, without any emotional sentiment attached to one of the parties or more of the parties. Now, these are issues that are looked at in deciding whether a matter should even go before a court or before a judge. But let's take a deep dive away from there and let's come to the conversation that we have today. Remember that we've been on the conversation about understanding court system in Nigeria. And last week, my colleague on set discussed about magistrate courts in Nigeria. And today, I want to take it further. I'm going to be guiding you on another court in Nigeria, which is called the High Court of the various states of Nigeria. In essence, the High Courts are usually state courts. So it's why whichever part of the country you're joining from, you might be hearing state high court. So the different states of the federation, including the FCT, the Federal Capital Territory, all of these states have their separate state high courts. And interestingly too, they enjoy the same kind of jurisdiction. Jurisdiction would mean they are able to do about the same thing because it is the 1999 Constitution that gave birth, that established the high courts of the various states. And precisely, if you allow me to be a lawyer for some seconds, Section 270 of the Constitution says there shall be a high court for each state of the federation. So in essence, every state of the federation is supposed to have a high court of the state. And they exercise power as may be captured in the Constitution and in the law that gives a broad scope of what they can do and what they can't do. Actually, there's been this conversation about high courts have the most jurisdiction. They have the most power to, adjudicate, to take on tests of jurisdiction, if you allow me to use that word. So, Section 202 talks about the power, the jurisdiction. That means what the state high court, the subjects that they can entertain. And broadly speaking, this is very broad. But when you go to each state of the federation and you still check the state laws, then you will begin to see more information about the scope of power and the scope of subject matter. A state high court can take on cases, we'll say, that originally comes before it, and can also take on cases that are as a result of appeal. Appeal would mean that maybe the matter had happened before a lower court, a court that is under the supervision of the High Court of the state. So such court could be magistrate court, it could even be customary, sometimes it could be district court, it could be area court, depending on the state of the federation where the matter is being dealt with. So let's say, for instance, that you had a matter at the magistrate court and you weren't satisfied with the results, with the judgment in that case. You have a right to then say you are appealing to the High Court of the state. Now, there is this language that is used for state high courts. They will say they are courts of record. What does it mean to be a court of record? Let's try to dissect it from the layman angle. Court of records could simply mean that, well, in that court, so when, for instance, the lower court may be a summary court where things could be done summarily, get to court, listen verbally, orally, move on and all of that. But court of records would mean that there has to be proper recording. There has to be process. There has to be a form of procedure for its activities. And this is one of the reasons it sometimes looks like high courts are formal, and sometimes it looks like lesser courts are less formal. This is also one of the reasons it sometimes looks like high courts takes forever to get matters resolved, while sometimes it could also look like lower courts get matters done very fast. So you begin to understand all of these things around courts and how they operate. And the moment you begin to understand, then it's easy for you to make good decisions. Sometimes too, there are subject matters that by virtue of the law relating to the subject, you are allowed to either approach the High Court or even go before a lesser or a lower court. One of such examples is the case of custody of a child. So you want to sue on a matter relating to family court. Especially, now I don't mean divorce, because divorce may not necessarily be a subject of magistrate court, except, of course, the subject matter is customary marriage. But when it's a marriage under the statutes, a statutory marriage, then it can't go before a magistrate court. And then customary marriage would even need to go before a customary court if it has to go that route. So back to the conversation. Issues relating to child custody, by virtue of the law, allows both a magistrate court and a high court to sit on such matter. So in essence, it is what lawyers will say they have concurrent jurisdiction. They are able to handle that subject matter together. So you are somebody that is seeking for justice or wants to approach the court, may just decide to go to either High Court or go to before a magistrate court, the family unit of the court. So these are some of the things that are interesting to note about High Court of the states of the different, High Court of the different states of the Federation and how they operate. What more? Now, the High Court, for you to be a judge, you must have practiced as a lawyer for a period of time before you can apply to become a judge. And usually, depending on the subject matter anyway, but usually one judge sits at a time. And when there is a need to get professional hands to look at a subject matter, the court can call for professionals to come and act as assessors. I think that's the word, to come and act. And minus that, sometimes too, you would find in some states where, depending on the subject matter, a court can sit in 2 and 3, depending on the subject matter. But generally speaking, one judge usually would sit as a judge of the High Court. And when you're unhappy and unsatisfied about the decision of the High Court, the next place to appeal to is called the Court of Appeal. Now, you need to get this clearly too, because in some states of the Federation, we also have what is called the Customary Court of Appeal. In practice, the Customary Court of Appeal, and then in some other parts too, we have Sharia Court of Appeal. Now, in practice, whether it's the Customary Court of Appeal or the Sharia Court of Appeal, these are considered to be courts of equal power, equal jurisdiction with the High Court. So even though they are known as appeal, so because when you hear the word appeal, you might think that, oh, they are a level above High Court. Why they are a court of appeal is because usually there would have been a Sharia court, which is a lower court. There might be a customary court, which is a lower court. And when there is an appeal from that customary court, it goes to what is called the Customary Court of Appeal or the Sharia Court of Appeal, as the case may be. But High Court, Sharia Court of Appeal, these are courts of coordinate equal jurisdiction. And that includes National Industrial Court, it includes Federal High Court, which is a federal court. High courts have broad jurisdiction, except for where it's categorically stated that they don't have the jurisdiction. So, for instance, when it relates to matters involving federal subject matters, most likely it goes to the Federal High Court. When it relates to industrial matters, employment dispute, labor relation, it goes to the National Industrial Court. And when it involves matters relating to the custom of the people, whether it's a marriage, any other subject matter around custom, and then if there exists customary courts within that state, then appeals goes to the Customary Court of Appeal. And these are interesting things that you may begin to note about the state High Court and how it operates. So appeals from state High Court usually will go to the Court of Appeal, which is just a step before the highest court, which is the Supreme Court. I hope you've had fun in today's conversation, and remember to drop your comments and also drop your questions, and we'll pick them up and we will carry on with the conversation right in the other room in the comment box. Thank you for joining today. You have for yourself a wonderful, wonderful Good Friday and Easter weekend. Bye.